So in today's session, we're going to focus on the landlord's statutory and contractual responsibilities that underpin their role within the private rented sector. Now, in light of the ongoing reforms and changes in legislation, it's more critical than ever for landlords to understand their obligations, but also to ensure that they comply with both the legal and the contractual obligations. So let's begin with the pre-tenancy stage. This is a period that is often underestimated, yet it's one that is absolutely crucial to ensure legal compliance. So this is from the get-go. From the outset, landlords must ensure that all the correct paperwork is in place. Now, this includes elements that sit under the Deregulation Act 2015, and then contractual, and then housing law. So application forms that are often digital now through lots of different providers and platforms to identify the tenant and to conduct the referencing process. A compliant holding deposit form. So the holding deposit can be taken, the equivalent of 1 week's rent, but we need to make sure that that is identified correctly. The tenancy agreement and fees to ensure that the landlord complies with the Tenants Fees Act and does not charge prohibited fees. And also within the tenancy agreement, which is pretty much the core of the relationship between the landlord and the tenant, is to be sure that the contract has all the relevant elements. Now, the contract has to be carefully sourced and drafted. Some landlords rely on landlord organisations or their solicitors, but whether the contract is a license agreement and a short hold tenancy, a holiday let, it's important to understand that these are formally binding contracts. Pay attention to things like grammar, spelling, and so on. We want to make sure that any contract is as it should be, because potentially mistakes can invalidate the contract. We also need to think about the accompanying documents, as I said, under the Deregulation Act. So these relate to prescribed information, and that has obviously an impact on tenancy deposit protection law. The relevant copy, up-to-date copy of the How to Rent Guide, a valid gas safety certificate where there is gas, energy performance certificate where the rating is C or above, a valid electrical installation condition report known as an EICR, and HMO licenses, additional licenses, selective licenses where applicable. Okay, so that's very, very key. Failure to serve these documents in advance of the tenancy commencing would mean that any Section 21 served, and obviously we're not thinking about the Renters' Rights Act now, but any Section 21 served would invalidate that notice, okay, and have an impact on the landlord trying to get possession. So that's extremely important. So the next element to think about is maintenance and repair. Now, the landlord has some very significant responsibilities under the Landlord and Tenant Act, sections 11 to 16. This imposes a statutory duty on landlords to keep in good repair the structure and the interior of the property, as well as key installations for gas, electricity, sanitation, and water. Okay, so those responsibilities, unless otherwise proven, sit with the landlord. So when a tenant raises a repairing issue, it should not be ignored. Okay, so it's not unusual for tenants who struggle with issues that relate to maintenance and repair, seeking legal advice and requesting a pre-action protocol that the landlord must abide by. And this would require the landlord to meet certain deadlines provide documents, and ultimately, if the landlord doesn't comply with the protocol, this could lead to court proceedings, financial penalties, and even a counterclaim if there is a possession proceeding. So it's really important for landlords to understand that, as I said, unless otherwise proven, the responsibility for maintaining and repairing everything within the boundary of that property sits with the landlord. So we need to think about audit trails, and the audit trail starts with the beginning of the tenancy, and that would be the inventory and check-in. But we also need to think about the records that we keep for rent payments, maintenance requests, any communication with the tenant. And it's always better to overdo and keep the audit trail strong, because the landlord doesn't ever know when they're going to have to rely on this information, either in relation to a complaint or to a legal dispute. Okay, so keep that audit trail strong. Now, statutory obligations also include elements that relate to health and safety. So we have smoke and carbon monoxide alarm regulations, which were introduced in 2022. So there is a legal requirement that carbon monoxide alarms are required in all rooms where there is a fixed combustion appliance, and landlords must repair or replace faulty alarms that perhaps the tenant has reported. Okay, smoke detectors as well, the landlord is responsible for, and ensuring that the smoke detectors and the carbon monoxide alarms are tested on the day of move-in, and best practice would be to ensure that they're tested during property inspections as well. Now, another critical obligation for the landlord are the right to rent checks. These were introduced under the Immigration Act 2014, so they've been around for a while, and landlords must verify that all tenants and occupants 18 and over have the right to rent in the UK, and this applies to all nationalities, including British. Okay, so that's very, very important. So we don't want to avoid discrimination, and we need to make sure that the landlord has a really good understanding that this process has to take place pre-tenancy and then every 12 months. So extremely important. Records need to be kept, and a very good point of reference for the landlord is the Home Office website. Now, I've said that we're not talking about the Renters' Rights Act, but we're talking about situations in real time. So we need to address the fact that if a landlord wants to obtain possession, the landlord must rely on a Section 21 notice. They will have to consider pre-service of the notice that all the relevant documents are in place, that they are able to serve notice within the correct timeframes, and that if the tenant doesn't vacate, they seek legal advice and instruct solicitors and a legal firm to assist with accelerated possession. Okay, so that's very, very important. Now, Renters' Rights Act, we actually don't have an act yet. It's the Renters' Rights Bill, and this will completely abolish the Section 21. So I've mentioned it because that element is still current and still in existence. So we just need to be sure that landlords have a really good understanding that the Section 21 notice is the go-to generally if they want to obtain vacant possession. So, in conclusion, statutory compliance and contractual diligence are not optional extras for a landlord. They are fundamental to the running of the landlord's business. Okay, so the landlord needs to operate a very lawful and professional tenancy. And as this sector evolves, which it clearly is, those who are prepared and informed and proactive will not only remain compliant and avoid penalties, but their business will thrive.